Have you ever wondered if a landlord can ask a tenant to move out even if they haven't violated their lease or done anything wrong? It is a common question for both tenants and property owners, and understanding the rules is crucial for smooth rental experiences. A landlord can issue a no-cause termination notice primarily in specific circumstances, generally when there is no fixed term lease in effect or when allowed by strict local regulations. This typically applies to month-to-month tenancies or when a fixed term lease is simply expiring and not being renewed. The ability to do so depends heavily on local tenant-landlord laws, which vary significantly by state, county, and city. The core reason behind these rules lies in the distinction between different types of tenancy agreements and the evolution of tenant protection laws. In an at-will or month-to-month tenancy, either the landlord or tenant can usually terminate the agreement with proper notice, as long as it is not for a discriminatory or retaliatory reason. However, for fixed-term leases, a landlord generally cannot issue a no-cause notice until the lease term officially ends. Many jurisdictions, especially those with rent control or what are called just-cause eviction laws, have further restricted a landlord's ability to end a tenancy without a specific, legally recognized reason, even for month-to-month arrangements. These laws are designed to provide greater security for tenants. So, how do you navigate this as a property owner? First, always review your specific lease agreement to understand its terms regarding termination. Second, it is essential to research and understand your local and state tenant-landlord laws. You must adhere to the statutory notice periods, which commonly range from 30 to 60 or even 90 days depending on the jurisdiction and how long the tenant has resided in the property. Providing proper written notice, in the format required by law, is absolutely key to ensuring a legal and smooth process. Understanding terms like just cause eviction ordinances and statutory notice periods can give you an edge. Just cause laws mean a landlord needs a specific, approved reason like non-payment of rent, lease violations, or wanting to move a family member into the unit to terminate a tenancy. Without such a law, no-cause terminations are more broadly permitted for month-to-month agreements, provided the correct notice is given. Always remember that even in areas without just cause laws, a landlord cannot terminate a tenancy for discriminatory reasons based on protected characteristics like race, religion, or familial status, or in retaliation for a tenant exercising their legal rights. By knowing the specific type of tenancy you have, staying informed about your local and state housing regulations, and adhering to strict notice requirements, you can effectively manage your property and ensure that any termination of tenancy is handled legally and fairly. This proactive approach helps protect your investment and maintain positive tenant relations, even when changes become necessary.